Good morning, everybody. Sorry for the slight delay. We will open the meeting. I'll receive apologies of absence first, Matt.
Yeah, we have apologies from Councillor Angie Fitch-Tillett, Councillor Gary Bull, and also, I believe, Councillor Roy MacDonald. We have Councillor Andrew Brown substituting today.
Thank you for that. Any items of urgent business?
None received.
Thank you very much indeed. I think we'll go for declarations of interest. So if we introduce ourselves, yes. Sorry, no.
Ladies first.
Nigel, you want to go first? Yeah.
I will. Thank you, Mr. Chairman. Yes, Councillor Nigel Dixon, Houghton and Tunstead Ward. The interest that I need to declare today is that the subject member is known to me. In a previous administration 4 years ago, we were district councillors. We also share the same party membership. And I'm also Councillor Withington is known to me. So I declare those interests, and I do not see them as affecting my judgment in the matter today.
Thank you very much.
Thank you, Mr. Chairman, and good morning, everybody. My name is Lucy Shires. My declarations are: I am a member of the Liberal Democrats. I'm a serving Liberal Democrat councillor. The complainant is known to me through my service on this district council, and I'm aware of the subject member through political campaigns and election periods.
Thank you very much.
Pauline Porter, Bacton Ward. Both the subject member and the complainant are known to me, but not to a degree that will affect my objectivity. I'm also a member of the same Conservative Party as the subject member.
Thank you.
Good morning, everybody. My name's Andrew Brown. I'm the Liberal Democrat District Councillor for Stoddy Ward. I'm also in the Cabinet of the current administration, and I am known to the complainant, who is fellow Cabinet member serving with me. And like others have said, I am in no way predetermined on this issue. That's pretty much all I've got to say.
Thank you very much. And I am Harry Blathwaite. I am the Liberal Democrat member for Hickling Ward. I too know the complainant, though I have never met or know the subject matter. I am sure we can all be subjective. It would be very strange to hold this if we weren't all aware. The very nature of the item we're discussing today means that we are likely to be aware of the people involved. Thank you very much. I will ask the monitoring officer to outline the procedure for the hearing. Cara, please.
Thank you, Chairman. Just so that I'm introduced here, I'm Cara Jordan, a monitoring officer. If I could introduce my fellow officers.
Matt Stempovich, Democratic Services.
I'm Mary Lou Clark. I'm the investigating officer for this matter.
Thank you. And I understand the two complainants are here with us today, and we'll speak later on about whether the matter should proceed in public or private, but they've indicated that they are happy to be identified here today. So in regard to the procedure, firstly, we will discuss any preliminary issues, and the issues to be discussed are whether the matter should be in public or private session, and whether the matter should or should not proceed in the absence of the subject member, who isn't here today. I should also at this point mention that the independent person isn't present. However, he has provided his views, which I will read out at some later stage, as the committee must take into account his views before coming to a decision. So after those preliminary issues are dealt with, then providing that the matter is proceeding, the chairman will invite the investigating officer to outline her report. Members may ask questions of the investigating officer. Thereafter, at his discretion, the complainants will have an opportunity to give any representations. I will inform the committee of any written representations received by the subject member and by the independent person. Thereafter, if there are any closing statements, and that would only be by the investigating officer, as there's no one else here, the committee will usually retire to consider their decision after I've given any additional advice. After making their decision, if any breach is found, the members will return and consider whether there are any representations from the investigating officer as to sanction, and also whether there are any, whether I have any information from the subject member or from the independent person as to sanction. Again, members will usually retire to make the decision and announce a brief summary of their decision with a written decision notice provided shortly thereafter. So there are two preliminary issues, and these, as I have mentioned, relate to the question of whether to proceed in absence or whether the matter should be in public or private session. And in fact, in a different, although I was going to look at presence, first of all, I think I will deal with the matter of whether the matter should be in public or private session in the first instance. So members need to consider, so I'm considering point 5 first of all on our procedure note. So what is the starting point? The starting position should always be in favour of a public hearing. It should only be in private in limited circumstances where there is justification in law for doing so. So the next question is there justification? Justification for hearing a matter in private may be found in Schedule 12A to the Local Government Act 1972, and includes where individuals are or are likely to be identified. So what is the position here? This is the third point you consider. The information currently in the exempt papers is capable of identifying individuals. And this means that members of the committee will need to consider all the relevant information and decide whether the public interest falls in favour of having a hearing in public or whether it falls to having the hearing in private. The fourth thing to consider is what can be considered as in the public interest. So the information is likely to identify individuals, but is it in the public interest to have the matter in public? So some things that are in favour of being in public are the general public interest in transparency. There may also be a legitimate public interest in the subject that the information relates to, for example, member conduct. Another matter that's in favour of the public interest is that others are able to understand the full picture rather than just part of it. And matters against being in public is that there are specific circumstances in a particular case that may reveal a compelling reason to hear the matter in private. And another reason is if it affects the right to a fair hearing or impacts so severely on privacy rights. Fifthly, what information in this case assists you as members of the committee in deciding whether it's in the public interest to hear the matter in public? Well, the papers identify individuals. The complainants in the matter were contacted and are here today, and I have spoken to them today, and they have both informed me that they consider that the hearing should be in public and that they are content to be identified. And I wonder whether those complainants at the back could confirm that that is their position. Thank you, both confirm. The investigator, I wonder whether you could set out whether you consider the matter should be in public or private session.
I have no objections to the matter being heard in public in favour of transparency and the public interest, as long as no reference is made to sensitive data and any note of a third party can be adequately managed by not referring to them by name.
Thank you. Chairman, I have also contacted the independent person, and it's his view that public proceedings seem right to him. He sent me that by email. And in regards to the subject member has been given the opportunity to provide his views on at least 2 occasions as to whether it was his view or whether he had any representations as to whether the matter should be heard in public or private session, and he has not responded on that point. As he has not responded, I'll give the committee some advice as to the privacy rights of elected members. There have been previous tribunal cases on the matter of identifying elected members. Such individuals are distinguished from ordinary members of the public, and this is because they hold public office and should expect considerably more public scrutiny for their actions insofar as those actions are relevant to their public office. Members of the public will have a legitimate interest in hearing information relating to standards in public life, and councillors, a councillor subject to a complaint and a hearing may look to seek re-election in the future, and there's an argument that they should not be protected by the withholding of information which could impact on future voters. And I'm referring there to some particular findings in the case of Deadman, which actually related to releasing a draft investigation report. So they are the comments in regards to the preliminary matter regarding whether the matter should be in public or private. So in the first instance, I would advise members to consider that matter, and thereafter you can consider the second preliminary issue as to whether or not to proceed in the absence of the subject member.
Thank you very much. Thank you for that. Can I just ask, it is recorded, you did record and can evidence that we tried to contact the subject matter regarding this, and we can evidence that in future if we are asked.
Yes, I can confirm the emails and the dates that I have contacted the subject member to try to get his comments on this.
Okay, thank you very much for that. So, I guess we need to establish whether we need to go into private session just to discuss this matter, or are you content to have a vote on it now? Nigel?
Thank you, Mr. Chairman. In respect of private or public session, I see no exceptions that would justify going into private session, so I would be comfortable in keeping in public.
Thank you very much. Lucy, would you like?
I'm supportive of this being held in public session, more so because a lot of these instances did happen in public view, which would support public interest.
Thank you.
I agree with councillor Shires. Most of it's been in public and I think the hearing should be in public.
Thank you, Pauline.
I concur, Mr. Chairman. I have nothing further to add to the reasons given by the members of the panel. I think it's entirely appropriate that it is held in public.
And I, as chairman, concur absolutely that this meeting should be held in public. So I think on that, we will hold this meeting in public. Thank you very much. Right, I asked Cara, is there any other relevant information received and to provide any evidence for the committee to assist with their consideration as to whether this matter should be heard in public or private? And we've done that. Thank you very much.
If I could, sorry, I've done these. So if I could speak to, if we could go to Foray.
Foray, okay. So preliminary issue 1, where the subject member is not present. So ask the investigation officer if she is in a position to proceed and of any views as to the proceedings in the absence of the subject member.
Thank you. The subject member has had every opportunity to provide a response to both the draft and the final investigation report, and the investigation report takes into account the subject member's submission in the initial assessment. It would be my submission to proceed to avoid any further costs or time to public resource. Thank you.
Okay, and similarly, I invite the monitoring officer to present any information and advice regarding their decision as to whether to proceed in absence. And I think we've kind of done that. Haven't we? Yeah.
I do have some advice and some information for the committee to assist you in
Right,
making
yes, please.
your decision as to whether to proceed in the absence of the subject member. Where the subject member is absent from the hearing, to consider the allegation as to whether he's breached the code of conduct, members will need to consider whether or not they can fairly proceed in his absence. You are able to proceed in absence, but before so proceeding, you should consider Article 6 with reference to the Human Rights Act, which is the right to have a fair hearing. If it would not be fair to proceed, you will need to adjourn the matter for a new date to be fixed. In considering whether it would be fair to proceed, you will need to consider any information that you have about the absence. Is the subject member aware of the hearing, for example? Has he informed the council that he will not be attending? What are his views about whether or not it should be in public or private, and has he asked for the matter to be postponed to another date? So to assist you with some of those questions, I will refer to some of the correspondence that I have had with the subject member. So in addition to what you've heard from the investigating officer about the sharing of the draft report and the final report, I contacted the subject member by letter. A colleague of mine attached it to an email from the legal section, letting the subject member know that the hearing was fixed for the 30th of June. And in that letter, he was asked, he was informed that he was entitled to both attend and make representations. He was asked whether he wanted to call any witnesses, and also asked matters in regards to public or private session, whether he had any views. As he didn't respond to that, on the 16th of June, I sent him a follow-up email, and in that email, I again informed him that the hearing date was fixed for today to consider the complaints against him. I asked him again about whether he had any views about public or private, whether he wished to call any witnesses. And I informed him on that date that if you do not attend, the hearing may proceed in your absence. The committee will decide whether or not to proceed in your absence with regard to all the circumstances. And so I asked him to inform me whether he would be attending and provide me with any comments if he wasn't attending that he wished the committee to take into account. Also at that time, informing him of the details of the independent person who he may contact. And then on the 18th of June, there was a phone message from the subject member, followed by an email. And in that email, the subject member explained some personal issues. He said he didn't know what this complaint was about. And he said that due to a possible hospital appointment at the last minute, he didn't know the date. He couldn't see himself attending. And he said, so it seems the best thing to do is to continue without me. On the following day, the 19th of June, I contacted the subject member, and I advised him that I would tell the committee of that comment in regards to he may not be attending, but to let me know if he was attending, and if he wasn't, to send any written comments for the committee to take into account in regards to his view of the report, its findings, and any sanctions that are mentioned or otherwise, public and private issue. And I also informed him on that date that the Democratic Services team would be sending out papers to him on or before the 21st of June. So to ask him to check his email, because the independent person's comments will be included in those papers. And so before sending any representations, he might want to consider those comments. And then Democratic Services team sent out the papers to the subject member on the 22nd of June. On the 28th of June, the subject member contacted a member of the Democratic Services team, informing that he hadn't heard back from me. So the following day, when I was informed of this, I sent him my email again that I've advised you of earlier. And the subject member again got back to the Democratic Services team saying that he wasn't aware what this was about. But I understand he was informed that it was in the same email trail as the agenda item. So that's the information in regard to the communications with the subject member and his knowledge of the hearing today, although he has said he doesn't know what the subject matter of this was, but it was included in one of those email chains. So in deciding whether to proceed in absence, you'll firstly need to be satisfied that the subject member has knowledge of the hearing. You will consider the views of the interested parties as to whether it would be fair to proceed. And if you decide to proceed, the matter will need to be conducted as fairly as possible in regard to rights to a fair hearing in light of any absence of the subject member. So you may wish to retire, or you may wish to stay here and consider the matter of whether to proceed in absence or to adjourn to another day.
So, I mean, basically, if we have a quick vote to see if all members are happy that we continue without the subject matter being present. Basically, Nigel, you wish to speak?
Thank you, Mr. Chairman. Yes, I'm content to proceed in absence.
Yeah, absolutely. Lucy?
Yeah, as am I.
Yes, agreed.
Thank you.
Yes, I'm in agreement. I think the subject person has actually in effect consented, if I understand the content of email traffic from the monitoring officer correctly. And whether there's a medical appointment that precludes him from attending today seems to be a moot point really in that case.
Well, yes, I agree. Continue without me is the quote. So I think that expresses permission for us to continue without him. Thank you very much. Preliminary issue 2, do we?
So we're now on to item.
All right. Right. So I announce formally that we will proceed. Mary Lou, please, as investigating officer, outline the complaint and present your report, please.
Thank you. So you will all have received and processed my final report, written following my investigation into the allegations before you. I do not propose to read the report, however, but for the purposes of the recording, I will take you through the significant points. Firstly, a summary, its relation to the law, a summary of the evidence, and then a summary of my findings and recommendations. You will note from my report that the investigation was surrounding the following 6 allegations. Incident 1 was a social media post criticising a local support group and the complainant counsellor. I note with this incident, a complaint was received by the subject counsellor and a member of the public. Incident 2 is a social media post with the image of Baconsthorpe Castle and a comment, which I will now quote, "Photo of the bloody tower where libs, one in particular, may be beheaded, including," I'm redacting this element as it's a third party, but it is known to be a Liberal Democrat councillor. The one in particular is believed to be in reference to the complainant counsellor and was also noted to be the complainant counsellor by a member of the public. Incident 3 is another social media post where the subject member implies someone had thrown weed killer over their lawn as a potentially politically motivated attack. Incident 4 refers to yet another social media post, of which is considered outside the scope of this investigation. Incident 5 is another social media post relating to parking and double yellow lines. Incident 6 involves encouraging a member of the public to make a code of conduct complaint, encouraging police involvement with the intention of removing the complainant as counsellor. Accordingly, I propose to focus on allegations 1 through 3 and 5 through 6, where I did find sufficient evidence to support a breach of the code of conduct. Now the matter has been introduced, I will focus on the legal backdrop that underpins this investigation. Firstly, Article 10 of the European Convention on Human Rights. It's a fundamental human right. Everyone has the freedom of expression, which includes freedom to uphold opinions, receive and impart information without interference by public authority, regardless of frontiers. This is a qualified right, and it only may be restricted if the restriction is prescribed by law. It is necessary in a democratic society for the protection of the rights and interests of others. Therefore, it is important to note it is the burden of the council to justify interference with these fundamental rights. In this instance, the Localism Act 2011 and the standards thereunder provides the relevant authority, section 28, or more commonly, the Nolan principles, which require conduct to be consistent with the following: selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. The reading of these principles is to ensure that conduct in public life does not fall below the minimum level, whilst also bearing in mind the importance of freedom of political expression. As Exhibit 3 on page 63 shows, Sheringham Town Council recommended the adoption of the Model Code of Conduct to the meeting of full council on the 17th of August 2021. Indeed, case law, specifically in Heaton v Public Service Ombudsman for Wales, considered freedom of speech for elected individuals, a highlight of which, and I now quote, a degree of immoderate, provocative, emotive, and non-rational speech is to be tolerated. And even aggressive, offensive, and shocking speech may have its place in the cuts and thrusts of political life. The case goes on to state, and I quote again, whilst in a political context, Article 10 protects the right to make some incorrect but honestly made statements, it does not protect statements that the publisher knows to be false. Furthermore, any restriction should have a pressing need. Politicians are required, and I quote again, to have a thick skin. Nonetheless, purely personal abuse or deliberately false statements do not benefit from the enhanced protection given to political expression. My final note on the legal backdrop is the matter of R. Mullany v. Adjudication Panel, to which I quote again, the concept of respect is perfectly capable of being applied by a reasonable person. Failure to treat others with respect will occur when unfair, unreasonable, or demeaning behavior is directed by one person against another. In order to make a finding against the subject member, you must be satisfied for each of the allegations as follows. At the time of the alleged conduct, the subject member was acting as councillor or representative of the Sheringham Town Council. Secondly, that on the balance of probability that the alleged conduct occurred. And thirdly, the conduct complained of comprises a breach of the Sheringham Town Council Code of Conduct. So firstly, the issue of capacity. Although there is no formal description of what the role of a councillor is, but aside from local authority business, it would include promoting and representing the local authority in the local community and acting as a bridge between the community and the local authority. This includes interactions with the public as well as fellow councillors and local authority officers. I would say in incident 1 through 3 and 5 through 6, they're all political in nature, discussing a fellow councillor, political opposition, and local authority business. For these reasons, it is my submission that the subject member was acting in their official capacity. I am satisfied, therefore, in accordance with what I've outlined in the report, that the councillor was conducting the business of Sheringham Town Council and giving the impression and or acting as a representative of the parish council in the social media postings and in the exchange with a member of the public in incident 6. Next, was there a breach of code? Incident 1, the subject member's response to a community group seeks to impede its success based on its association with the complainant councillor. The comments are entirely unnecessary, creates an unwelcome, hostile environment, and discourages participation in community and political activity. It is important for councillors to treat other councillors with a degree of respect. Incident 2, one of the more egregious social media posts, centres comments on the beheading of a political opposition at Baconsfield Castle. The subject member defends this comment with the suggestion it was meant to denote humour. As articulated previously, a degree of provocative speech may have its place. However, this goes beyond the highly protected scope afforded to political expression. It is both personal abuse and violent and should not be tolerated. Incident 3, where the subject member alleges that someone has thrown weed killer over his lawn. He suggests that it has to be political. This is an irresponsible posting. We do not know it to be a political attack. In suggesting so, the subject member is misleading the public by making a statement it does not know to be true. Remember, the code protects incorrect but honestly made statements. This is not one of those. Incident 5 is another social media post regarding parking and yellow lines, as well as the suggestions of imposing, and I quote, daft ideas with IT, which has cost thousands. The frequency of fault finding and nitpicking is ultimately malicious in nature. It shows harassment toward the councillor complainant and an attack on her projects and integrity, and fundamentally it brings Sheringham Town Council into disrepute. Incident 6 involves the subject member visiting a member of the public's place of work, with the attempt to encourage them to write a code of conduct complaint or consider the police on 2 occasions. The subject member allegedly said, and I quote now, "Get rid of," and this element is redacted, "that bloody woman as councillor." I'd like to say at this point, it's not so much the advice offered as much as it is the deliberate seeking out of a member of public to make a complaint. As for the remark, "that bloody woman," it is derogatory, it's offensive, and a councillor of the subject member's experience should be more alert to making misogynistic comments. The issue is further compounded by the subject member's denial of any wrongdoing in the initial assessment and insistence that his actions were entirely appropriate. There has been clear opportunity to make an apology for his actions and further opportunity to reconsider this position when provided with a draft report and preliminary findings, which would have illustrated a greater degree of integrity and remorse. For all the reasons I've presented to you today, it is my recommendation that the complaints are about a serving councillor and took place during his term of office. Therefore, it is reasonable for the complainants to assume their concerns fall within the scope of the standards framework. Some incidents may seem minor in nature, however, the cumulative impact is not to be underestimated. They are dogged personal attacks that amount to a failure to treat others with respect, bullying, and an attack on the councillor complainants, projects, and integrity. This consequently brings Sheringham Town Council into disrepute. All in all, it is my recommendation to the committee that the subject member has breached the Sheringham Town Council's Code of Conduct on the counts I've illustrated in this verbal representation today and my written investigation report. Thank you.
Thank you very much. Very thorough. Sorry, where am I? I was so concentrating on that. 10. I invite questions to the investigation officer from members of the committee. Nigel?
Thank you, Mr. Chairman. I note in respect of incidents 5 and 6, I know that 4 is also in this category, but 4 is not a matter that we will consider today. So in respect to 5 and 6, there is no date given. And I wonder if you might give us an explanation as to why that is and whether it was possible to tie that down to a period of time more than just an unknown date.
So the reason it's an unknown date is screenshots were provided in the complaint and there was no distinguishable timestamp on those. We can see the initial complaint provided in the exhibit where you will see the screenshots, but that's the reason there is no date. It was not distinguishable in the screenshots, unlike the other ones.
Any further questions from anybody else? Yes, Lucy.
Looking at all the incidents, I don't know if that's the plural, apologies for that. Together, there appears to be, okay, I'll read out the link and then I'll try and formulate from there. Where we look at incident 1 and it talks about a beheading, and incident 3 talks about a political injustice from the perspective of the subject member. So it was incident 2, sorry, is the beheading. Incident 3 is the issue that I said previous. We then move on to incident 5, where the subject member identifies as a previously serving police officer using the issue of taxpayers' money from the insinuation of what he said relating to horrors. And then in instance 6, we talk about the getting rid of an individual. And if we link the wordage together and the threat that could accumulate towards, what is your opinion with regards to trying to incite hate or action based upon hate from this individual?
I would agree that the comments made throughout are violent in nature. I think that's what has brought us to this hearing today. It would be yeah, so I would say, obviously, as I've highlighted in my report, that those comments are inappropriate. They do breach the code for the reasons I've outlined. There may be more to it, but it's not subject to this investigation.
Yes, Andrew.
Yes, I mean, looking at the incidents in their totality seems to suggest a pattern of behaviour by the subject person. It would also seem to me to open the possibility of whether cumulatively this amounts to harassment of a particular individual, i.e. the complainant. We know that there is a procedure that the police can invoke under the Prevention of Harassment Act 1997. Have we as an authority considered that? Have we in any way at any stage consulted with the police as regards proceeding down that avenue at any point in the process?
I wonder if I could come in there. In regard to this hearing, there may be separate routes of dealing with the matter. And one of the areas in the Code of Conduct is bullying, harassment and discrimination, that members mustn't act in such a way to bully, harass or discriminate. And I think this hearing is to consider that, not the other avenues that may be
So
possible.
can I just clarify, are we saying that that is a process which is potentially pending, dependent on the outcome of this today, or is it totally unrelated to that process?
It's a separate consideration.
Right, but I don't think my question has quite been answered. Have we at any stage involved, or have any participants in the process involved? Okay.
We as an authority haven't contacted the police directly. The purpose of this investigation is to find whether there has been bullying, harassment. I think this investigation has done so, and provided recommendations of sanctions based on that information, using case law. If the police were to be contacted, it would have to be as a separate matter.
Thank you.
I think it's fair to say that there appears to be a fixation on an individual by the subject matter. And Sheringham Town Council, and I would suggest North Norfolk District Council to an extent, has a duty of care for our members. And would you say that Sheringham Town Council has exhibited a duty of care in this case?
I think as a local authority, obviously Sheringham Town Council has has the obligation to report any kind of wrongdoing to us. We can only kind of act in the kind of in the kind of scope of the law. So we can only take action and make recommendations on that basis. Beyond that, it is a private matter, the harassment, and it should be reported to the police accordingly. I appreciate there is a duty of care.
And if I could add in regard to a town or a parish council, if they consider that there is some potential wrongdoing by a member of their council, they can't investigate that. The procedure is it has to come to us and be investigated by us and come to yourselves as the standard committee, rather than be dealt with internally in an isolated way at that town council.
Thank you. Any further questions of the investigating officer? I think it's a very thorough investigation. I thank you very much for it. So at my discretion, do you think there's any further questions to be made?
No, not at this stage.
Not at this stage. Invites representatives from the complainants on the investigating officer. So I understand now this is a chance for Councillor Wivington and Pauline. Yeah. Do you have any questions? I'll go to Councillor Wivington first, and then you second one. Councillor Wivington, do you have any questions for the investigating officer? Do you want to come forward and use a mic, Liz?
Thank you.
All right, just make the representation you would like to make.
Okay.
Yeah.
Okay, my NNDC laptop has done the same as everyone else's is doing this morning, so I'm now on my rough notes from yesterday. So apologies. Can I just clarify before I start? And as the process that we're using at the moment, are we not meant to say the subject person's name?
You can say the subject
That's okay.
person's name.
Okay. The independent person in this report that's been completed describes this as a ramping up of a long-running campaign. And I do agree with that. However, I wouldn't say it's a ramping up. I would say it's been at that level for 2 years. And it's most unfortunate that Councillor Shepherd, who throughout this since 2019, when I was nominated to stand for Sheringham as a district councillor, fails to recognise that his behaviour is abusive, harassing, misogynistic and bullying. And as you've seen from your exhibits and what you've heard from the investigating officer today, he still shows no remorse and concern as to that fact. And that's despite him being a chair of NNDC, a district councillor for many years, and now a town councillor. And I do believe actually he became a town councillor merely to be able to continue to have a campaign against me. It's not just my view. I've been told by many people in the town that they can't believe a councillor is allowed to behave in this way. They don't understand the terms Nolan principles, but they know about integrity and they know about treating people with respect. And that's what the people in the town feel, that this has shown no respect and is certainly harassing and misogynistic. His sole aim since 2019, and I think you can see that in those posts, has been to try and prevent me from being either elected and from fulfilling my role as an elected councillor once I was elected. That has had an impact in our town as well, in that, as the investigation states, it has made STC, he's brought STC into disrepute. And that's had the impact of people not wanting to have anything to do with the town council. And as a result, there are 4 vacancies after this local election. So it's actually having more than just an impact on myself, it's having an impact on our local democracy. And I think that shows, and it's impacting on things that are happening in the community, and that's shown by incident 2, relating to the setup of Hugs hosting Ukrainian group. And, you know, his terms of talking about it being woke, etc. It means that people don't want to be involved in things. It means that people feel that they're going to be attacked. So it goes wider than just the one person who's at the centre of this. As councillors, we have a duty to exemplify high standards of behaviour. Councillor Shepherd has, through his behaviour, encouraged others to behave in a similar fashion. He's particularly encouraged those who may be vulnerable to become embroiled in his campaign. You're not considering the Carnival Caravan incident, but I believe it was available in the report. Am I allowed to say what was said in it?
I don't think we're considering that.
Okay.
We considered that outside
Okay.
the scope.
But it was another example of him encouraging violence. And as a result of that, others' behaviour linked to him became so bad, I couldn't go into Sheringham for a considerable period of time in 2020. Months I'm talking about, not just a few days. I had people swear at me in Tesco's and on the street, referring to, we've seen what you do. We've heard and seen on Facebook what you do. I've been ambushed and verbally abused in a chemist's for similar reasons. My whole family were frightened for me. And having 2 young sons who were seeing this going on, it was incredibly frustrating for them not to be able to do anything about it. They were really concerned after the beheading post that someone who was susceptible to being encouraged or perhaps being disenchanted, etc., would actually take something up and do something violent against me. As I said at the beginning, it's a sustained campaign. And early on in that campaign, there was a series of window stickers which went up all over Sheringham, on post boxes, bus shelters, windows of housing, including Councillor Shepherd's house in his front window on a busy street in Sheringham. Bus shelters, train stations, everywhere all over the town. It was a horrible sticker. I have got them here, actually. The police were informed and went round and told him to remove it. He told them it was Loki, the god of mischief, who had put it there and refused to take it down. And it was there for over 2 weeks. For 3 weeks, my sons and I had to go round first thing in the morning and at 10 o'clock at night, taking down all of these signs that had been put up. Now, he may not have been personally responsible for putting all of those up in Sheringham. I don't know. We couldn't prove who was doing it. There was one in his window. He was aware of it and he still refused to take it down. And it came from being encouraged by his campaign. I think you can all understand how difficult it is to go through something like that. It is only because I am a resilient person and I've got a lot of people who look after me and care for me. And I have a core belief of the importance of democracy that kept me going. I've had support from friends, family and colleagues, and that's been amazing. But most significant has been the support of Sheringham's residents. And this is what's kept me going. Councillor Shepherd is one person, he's a minority. And those residents have messaged me and written and phoned to say ignore him, we know what he's like. Many others, though, would not have survived this. And it is for that reason as well that I have gone through this difficult process to hopefully have it formally recognised that Councillor Shepherd's behaviour is not acceptable. It's inappropriate, it's unacceptable, and actually it's dangerous and it's divisive. And it's important that the general public know that Sheringham Town Council, who have done absolutely nothing about this, know that. And that something is done to actually stop it. It has been politically motivated, malicious, and it's been unbearable, and it has to be stopped. And I need to feel safe in my own town and my home again. But most importantly, I want to be able to support my town and district as a dedicated councillor and be the person that I've been elected twice now to be. And this just needs to stop. Thank you. I've got a very loud voice. I don't know if you've got use my. I will, thank you. Good morning. Thank you for letting me come today. The reason for me making this complaint was because of hugs. I went to Liz Withington, and said to her, I'd really like to do something for all the Ukrainians that are coming into town. And we put our heads together and we formed Hugs. And straight away, it was attacked, straight away. And I'm just a bit fed up with it, to tell you the truth, because it puts me off doing things and I find it very difficult. I did ask him to refrain. As I said, it was very upsetting and belittling to all our volunteers. We have been attacked for various things over the years, but this was the last straw, really. So that's why I put the complaint in. The other thing that happened was I also complained about the beheading incident, because during COVID, we ran something called Sheringham Community Support. And I run a befriending service for people that had mental health difficulties. And I tell you, there are people out there that are very vulnerable and they don't want to see this sort of thing at all, because some of them take it on board and they believe it. And that really frightened me. It really frightened me, because I have been with Liz when she's been attacked. And it's not funny and it shouldn't happen. And I was very worried about that. So I really wanted that stopped. Anyway, it's very sad because whatever Liz is involved in, it gets attacked. So in the end, you sort of think, oh, I really can't be bothered I don't want to be part of this. So it stops you doing things. Well, I do a lot in the community, an awful lot in the community, and I'm involved in a lot of activities. But I tell you what, I have seriously considered stopping. I have seriously considered, well, I know I was asked to be part of the council. No, there's no way that I would be part of a council with people like this, councillors that can do this sort of thing. It's really, really sad. And I'm hoping today that you'll take on board all the things and perhaps stop it. Thank you.
Remind you to use your microphone, Harry. Sorry, can I just remind you to use your microphone?
Any questions from any member of the panel? No, thank you. Thank you very much for both your contributions. Thank you. Has any further information or written representation been received by from councillor Shepherd?
As I think I advised the committee at the beginning of this hearing, I have invited representations but haven't received any. However, as we also discussed at the beginning of this hearing, the hearing needs to be as fair as possible, even though the subject member isn't here. So I would draw the committee's attention in particular to those parts of the investigators' report which sets out what the subject member's view is, in particular on page 16, and also the comments that he gave at the initial assessment stage, so that you do have his voice within this hearing as well. He says, if I just refer to the page 16, he did indicate that he had not intended to offend and was willing to apologise where offence was taken in respect of the complaint by Ms. Prince. And he also doesn't accept that he acted in such a way that amounts to bullying or harassment, or that he has been disrespectful in regards to Councillor Withington. And as I said, there's some further information from him on the original assessment notice, just so that that is also taken into account.
Thank you very much. Unfortunately, Councillor Shepherd's not here, so we can't ask any questions or pass any questions of his through to Councillor Withington or Paula Price. So we now move on to the independent person's view, and will you be reading that out again? Thank you very much. So we have the independent person's review now.
The independent person isn't able to be here in person today, but has provided his views in regard to the investigation report and his views as to whether or not there has been a breach of the Code of Conduct. And he starts off by saying that the Sheringham Town Council Code of Conduct applies to councillors when acting in their capacity as a councillor, which includes when such actions would give the impression to a reasonable member of the public with knowledge of all the facts that you are acting as a councillor, and it includes electronic and social media. All the incidents outlined, save for item number 4, which he hasn't listed, showed his view that the subject member appeared to act in his capacity as councillor. In regards to incident 1, and just by way of summary, incident 1 is making a social media post criticising a local support group hosting Ukrainian group support and Councillor Withington. He quotes that, and he says that the subject member's response to a local support group set up hosting Ukrainian group support hugs, which was advertised through a Sheringham Community Support Facebook page. The subject member has offered a qualified apology. If I have hurt Mrs. Prince's personal feelings, to the member of the public who helped set up the group, thereby admitting some degree of responsibility. But it also shows a lack of respect for a fellow councillor that goes beyond expressing, challenging, criticising, and disagreeing with views, ideas, opinions, and policies in a robust but civil manner. It is also a personal attack on a fellow councillor that is insulting and offensive, and a core breach of the Code of Conduct. You should not, however, subject individual groups of people or organisations to personal attack. That's in quotation marks. It also brings the Sheringham Town Council into disrepute. And then in regards to the second incident, which is making a Facebook post with an image of Baconsthorpe Castle and a comment, photo of the bloody tower where Libs, one in particular, may be beheaded. In regard to that, he says that the subject member does not appear to dispute that he was referring to Councillor Withington. His view is that it's purely personal abuse that shows greater concern for the disparaging those of political opposition than partaking in healthy discourse. And it's another personal attack that's insulting and offensive to another person and to Councillor Withington. In regards to incident 3, this is the making a Facebook post about someone throwing weed killer over his lawn. In regards to this, he says this is a serious allegation of criminal damage, conduct that the subject member suggests was politically motivated. It clearly brings the Sheringham Town Council into disrepute. The Sheringham Town Council social media policy says information that is published should be factual, fair, thorough and transparent. The suggestion of politically motivated attack here is neither factual nor fair. And then moving on to incident number 5, as 4 was considered to be outside scope. Incident 5 was making a social media post about parking double yellow lines with comments relating to Councillor Withington. And in regards to that matter, he says, again, this displays a clear and obvious lack of respect, subjecting individual to personal attack, which is insulting and offensive. He had said in this post, imposing daft ideas, making unfounded statements that goes beyond reasonable debate. It also is an unfounded and incorrect statement made about Councillor Withington wanting to put yellow lines down, as well as attacking her motives. And finally, in regards to incident number 6, which is encouraging a member of the public to make a code of conduct complaint or encourage police involvement so as to endeavour to remove Councillor Withington as a councillor. About that, he says, allegedly said in the hairdressers that they could then get rid of Liz Withington, that bloody woman, as a councillor. This is an offensive personal comment. It is also hearsay, as it does not relate to a complaint made by the person hearing the comment, but to a report made back to Councillor Withington, who then reports it. The fact that it is hearsay may not mean that it's inadmissible in civil or reporting. Plus, he notes that the subject member does not deny this account. He says he agrees with the monitoring officer assessment that there, I think that should be the investigating officer's assessment, that there has been a breach of the Sheringham Town Council Code of Conduct based on a course of conduct. He says, I agree that the cumulative effect amounts to a failure to treat others with respect, bullying and an attack on Councillor Withington's personal integrity. Therefore, I agree that the subject member offers an unfeigned written apology to Councillor Withington and that he completes standards type training on bullying and harassment training and social media training. He additionally says that he notes that these allegations are also borderline offences under the Protection from Harassment 1997, where the subject member has clearly pursued a course of conduct that a reasonable person would think amounted to stalking and harassment of Councillor Withington, notwithstanding the greater tolerance allowed for elected officials because of the degree of personal abuse involved. Moreover, the subject member does not appear to be acting with any law or reasonably in his personal attacks, which might allow him a defence. The hearsay issue under item 6 could simply be remedied by obtaining a statement from one of the staff who overheard the subject member comments. However, the need for the Sheringham Town Council to make a referral to the police would be strongly mitigated by the subject member's genuine written apology to Councillor Withington, backed by no further incidences of abuse of Councillor Withington. who could make her own complaint under the same Act, the need for which would again be strongly mitigated by an apology. They are the independent person's comments on this matter, Chairman.
Thank you very much. I think we've taken that on board. Right. Chairman invites the final closing statements. I think we'll offer a short break now, just so we can perhaps have a little rest and some concentration, so any further we can decompress slightly. And if that's all right by everybody, we'll take a 10-minute break and reconvene at 25 to 12. Thank you very much. Right, okay, thank you very much. We'll invite a final closing statement from the investigating officer. So, Mary Lou.
Thank you. As prior, I'd refer you to my investigation report and the verbal representation offered to you, the committee, today. I'm satisfied that the subject member was acting in his role as parish councillor, has on separate occasions and cumulatively breached the Sheringham Town Council Code of Conduct. There has been every opportunity for the subject member to engage in the investigation process, to apologise, and this would have certainly mitigated the breaches. I find it surprising that a councillor of the subject member's experience is not more astute to what is considered good conduct. Thank you.
Thank you very much. We take advice from the monitoring officer.
Members, before you retire, I will advise you and try to bring out some of the important issues that you'll need to consider in this matter, also bearing in mind that the subject member isn't present, so bringing your attention to anything that he has said previously, but obviously because he's absent, he hasn't got the opportunity, or he hasn't been able to do so today. So you're considering 5 allegations, and they are, as I've read out previously when discussing the independent person's views, 5 allegations. Allegation 1 relates to, or you're considering 5 incidents which have been complained of against Councillor Shepherd of Sheringham Town Council, and you need to consider whether, on the balance of probabilities, they reach the Sheringham Town Council Code of Conduct. So the 5 incidents that you're looking at is 1, making a social media post criticising a local support group, Hugs, and Councillor Withington. Incident 2 is making a Facebook post with an image of Baconsthorpe Castle and a comment, photo of the bloody tower, libs, one in particular, maybe beheaded. Incident 3, making a Facebook post about someone throwing weed killer over the subject member's lawn. There is no incident 4 because it was out of scope. Incident 5 is making a social media post about parking and double yellow lines with comments relating to Councillor Withington. And finally, incident number 6, encouraging a member of the public to make a code of conduct complaint or encourage the police involvement so as to endeavour to remove Councillor Withington as a councillor. So the issues that you will be considering are firstly whether Councillor Shepherd was in capacity. So first of all, you need to be satisfied that he was a councillor at the time of these incidents, and secondly, whether he was acting in his official capacity as a councillor. So that's acting in official capacity as a councillor isn't just saying I am a councillor, but it's carrying out official duties. For example, considering or discussing the business of the council. It would include promoting and representing the council in the community and acting as a bridge between the community and the council. It doesn't just solely apply to being at a meeting or saying you're a councillor. And here there are comments made on social media and some hearsay comments, and you'll need to look at what's been said and see if there's any link to the business of the council or to being a council, such as identification as such or suggestion that he is acting as a councillor. Then looking at the incidences that I have summarised, are those incidences agreed? Are they disputed? Are you satisfied on the balance of probabilities that they occurred? One matter that I would point out in regard to that, you've heard from the investigator, you've read the papers, you've heard from the complainants, and the complainants did perhaps speak more widely than the issues that are before you today. It's those issues before you today that you are considering, not those wider issues. And also you will need to consider what the subject member has said, even though he's not here today. Also take into account what he has said. And there are a couple of things that he has said that have been referred to at this hearing, and they can be found in the initial assessment notice. Although I understand he was provided with the draft decision notice and the final decision notice, he didn't actually present his comments on those. So all you have are the comments in the assessment notice. And in those, he did mention that if I have hurt Mrs. Prince's personal feelings, then I apologise. He also mentions in there finally regarding the Facebook portrayal of Baconsthorpe Castle, I'm not of the woke school of thought. So if anyone were to believe my comment, then something is wrong with this country. Please denote the final double exclamation marks, normally denoting humour. And he says there was absolutely no police interest. The other comment that he makes in the other assessment notice. I'm having trouble finding that moment. I don't know whether Miss Clark, you could, oh, I found it. On page 33, the other point he raises is yeah, in the subject member response, there is some comment that may not be relevant to the allegations, but for that part that you may consider, he says that I advise there may be enough depth in the letter. This is in regards to the hairdresser incident, to ask for police advice and to bear in mind asking the monitoring officer. As it turned out, neither route was taken. And he also adds, in conclusion, there appears to be a continuation of gagging where every time I criticise, a complaint goes in. Politics is never easy, even locally, and we must be allowed to fight our corner. So in that regard, he is raising the rights to freedom of speech. I won't go into great detail about that because you have heard from the investigating officer an outline of the law in that area. But very briefly, everyone has a right to freedom of speech. Politicians, all levels of politics have an enhanced protection where an enhanced protection in regards to freedom of speech. There's some further information on that. That's where something is said in good faith and there is some reasonableness to it in a political context that may be tolerated. However, clear personal abuse generally will not fall into that protection. So you'll consider, firstly, capacity, was he acting in capacity? Secondly, your findings on those incidences, taking into account what the subject member has said. And then the final part of that is it a breach of the Sheringham Town Council Code of Conduct? And in particular, you will be looking at the Code of Conduct, which is attached to the back of the papers. I would draw your attention to page 49. That deals with respect. It says, respect. As a councillor, I treat other councillors and members of the public with respect. I treat local authority employees and representatives of partner organisations and those volunteering for the local authority with respect and respect the role they play. And there's also some additional guidance within the Sheringham Town Council Code of Conduct based on the Model Code of Conduct, which explains a little bit about what respect means. Respect means politeness and courtesy in behaviour, speech and the written word. Debate and having different views are all part of a healthy democracy. As a councillor, you can express, challenge, criticise and disagree with views, ideas, opinions and policies in a robust but civil manner. You should not, however, subject individuals, groups of people or organisations to personal attack. In your contact with the public, you should treat them politely and courteously. Rude and offensive behaviour lowers the public's expectations and confidence in councillors. In return, you have a right to expect respectful behaviour from the public. If members of the public are abusive, intimidatory or threatening, you're entitled to stop any conversation or interaction in person or online and report them to the local authority, the relevant social media provider or the police. This also applies to fellow councillors where action could then be taken under the Councillor Code of Conduct, and local authority employees where concerns should be raised in line with the local authority's councillor officer protocol. You will also be considering, because of what has been said here, on page 50, Sheringham Town Council's Code of Conduct, point 2, bullying, harassment and discrimination. As a councillor, I do not bully, I do not harass any person, and I promote equalities and do not discriminate. ACAS, and it gives some further information. ACAS characterises bullying as offensive, intimidating, malicious or insulting behaviour and abuse or misuse of power through means that undermine, humiliate, denigrate or injure the recipient. Bullying might be a regular pattern of behaviour or a one-off incident, happen face-to-face on social media, in emails or phone calls, happen in the workplace, at work social events, and may not always be obvious or noticed by others. The Protection from Harassment Act 1997 defines harassment as conduct that causes alarm or distress or puts people in fear of violence and must involve such conduct on at least 2 occasions. It can include repeated attempts to impose unwanted communications and contact upon a person in a manner that could be expected to cause distress or fear in any reasonable person. It then goes on to mention about discrimination. And finally, on page 52 of the Sheringham Town Council Code of Conduct, disrepute. As a councillor, I do not bring my role or local authority into disrepute. And then the additional information describes that as a councillor, you're trusted to make decisions on behalf of your community, and your actions and behaviour are subject to greater scrutiny than that of ordinary members of the public. You should be aware that your actions might have an adverse impact on you, other councillors and or your local authority, and may lower the public's confidence in your local authority's ability to discharge your or its functions. For example, behaviour that is considered dishonest and or deceitful can bring your local authority into disrepute. And there is some a little more further advice there. So you're considering those areas in particular. I would advise if you consider any or all of those incidents are proved on the balance of probabilities, then you consider whether they also amount on the balance of probabilities to a breach of the code of conduct, in particular those 3 areas that I have read out.
Thank you very much for that. Before we retire, any questions for the monitoring officer? Any questions at all of procedure? No. Right, so we will retire and consider if we use the room.
Just for the purposes of the hearing, and as I realise it's being recorded, I will retire with the members, but I don't take part in the decision making. I just assist them with the formulation of facts and reasons for any decision they make.
Everybody ready? Yep, everybody. Apologies if it seems to have taken a long time. There we are. The decision and we considered all the information before the committee considered all the information before them, including the written and oral evidence. With regard to the 5 alleged incidents, it made the following findings. The committee is of the view that the subject member was a councillor at the time of the incidents and was acting in his capacity as a councillor. He refers to another councillor, namely Councillor Withington, talks about his being on the town council and discusses business relevant to the town council. Taking the incident separately and collectively, we consider he was acting in his official capacity. We consider that Sheringham Town Council had a code of conduct in place at the time, and we have considered the paragraphs which relate to respect, bullying, and harassment, and bringing the council into disrepute. With reference to the 5 incidents, we consider that on the balance of probabilities, they did occur. None are denied by the subject member, though we have considered what he said in regard to them in his communications. Having found that the incidents occurred, we have considered whether they breach the codes of conduct, and that we find individually and taken together that they do. The incidents taken together show intentional disrespect, which is over a protracted period and is repeated. The code of conduct details the requirement for respectful behaviour and that there should not be bullying or harassment. But the subject member's conduct shows evidence of victimisation of a particular individual who is repeatedly named. There are I can't say it, sorry. Yeah, comments which are not acceptable. A professional tone is not present. Words such as awful, dreadful, blame, sad, and stupid are present, as well as referring to an individual as that bloody woman. There is repeated, sustained, and violent language. The beheading comment is borderline inciting others to act. Whilst it is understood that there is the right of freedom of speech and members have enhanced protection, what is said goes beyond common decency and is abusive in tone and subject. To use the term ilk and call for beheadings, as well as referring to Councillor Wivington as that bloody woman, is not acceptable and is derogatory. While the subject member suggests that the beheading comments was said in jest, he is a retired policeman. And such a comment, especially given the recent attacks on some members of Parliament, including David Ames and Joe Cox, it is in no way humorous. It is concerning that there may be vulnerable persons who may not take comments in the way Councillor Shepherd says it was made. The subject member is a councillor of many years standing at both town and district level, and has also been a serving police officer. The inappropriateness of this conduct should be clear to him. We find a breach of the Sheringham Town Council's Code of Conduct in that these incidents taken together breach the requirement to act with respect, not to harass, and brought the council into disrepute. Thank you. So, where one or more breaches of the code has been found, Chairman will announce that the committee will now consider, if any, sanctions that should be imposed. I invite the monitoring officer to outline the sanctions available.
Thank you, Chairman. Where members have found a breach of the Code of Conduct, it may consider whether any sanction should be recommended. Any sanction recommended must be to the Town Council must be reasonable and proportionate and should be relevant to the subject member's behaviour. Sanctions which may be considered include a recommendation to the Sheringham Town Council of one or more of the following. A report of the committee's finding be made to the relevant Town Council, issue of formal censure, that the subject member makes an apology, removal from any or all committees that the subject member sits upon, removal from outside appointments where it's known that he is appointed by the town council, that the subject member undertakes specified training, that the parish council withdraws facilities provided to the subject member for a limited time, and that the subject member be excluded from the town council's offices other than when attending formal meetings. It's not an exhaustive list, but in particular with regard to the withdrawal of facilities and exclusion from the town council offices, any such sanction must not unduly restrict the member's ability to perform his duties as an elected member. But as I say, it's not an exhaustive list, and so they're an idea of the sorts of sanctions or recommendation to the town council that you can consider, Chairman.
Thank you for that. I invite representations as to possible sanctions. First from the investigating officer.
Thank you. Following your determination that the subject member has breached the code of conduct, I will now address you on the matter of sanctions I feel appropriate. Following what has been presented to you today, in accordance with the legal position in relation to the freedom of expression, any sanction imposed must be of the minimum that is necessary to uphold the public interest in local government being conducted to standards which maintain public confidence. I would remind you that the subject member has been given numerous opportunities to engage with the investigation process, offer an apology, and elect the relevant training. Despite this, I'm of the view that the breaches identified falls within the scope of an apology from the subject member to the complainants concerned, and wonder whether a finding from this committee would render the subject member more inclined to accept that the repeated social media postings at the claimant's expense and the deliberate seeking of members of the public to encourage code of conduct complaint against the councillor complainant is not appropriate behaviour. I would also urge the committee, if they see fit, to request the subject member attend some general standards type training, social media training, and bullying and harassment training, with a special emphasis on social media training. I appreciate that this could be considered a weak sanction considering the severity of the allegations. However, in support of the recommendation, I will refer you to the case of R v London Borough of Ealing, whereby a councillor posted on a blog that was public racist comments concerning an Indian community in Southall. The court upheld the original committee decision and required the councillor to issue a public apology. I note my report does say an unfeigned written apology, but in light of the case law provided above, if the committee would see it befitting, a public apology would be a sanction to consider. Thank you.
Thank you. Well, obviously the subject member is not here to represent themselves in this, but I will ask the monitoring officer.
Thank you. In regard from the independent person, I did read out his comments earlier, and he does make one comment in regards to possible sanction. He says that he agrees with the assessment that there's been a breach of the code of conduct, and that he agrees that the subject member offer an unfeigned written apology to Councillor Withington, and that he completes standards type training on bullying and harassment training and social media training. They're the comments from the independent person. As you've mentioned, the subject member isn't here. He was also given the opportunity to write in any representations in regards to possible sanctions, but he hasn't provided anything, Chairman.
Thank you very much. If that is all the contributors. We will retire and consider sanctions. Thank you very much. Right. Thank you all for waiting. Consideration as to sanction. The committee, having found a breach, gave all parties the opportunity to make any representation as to what, if any, sanction would be appropriate. The committee have considered the papers and any representations made, considered there were mitigating and aggravation factors, and took the following into account. Aggravating factors. As mentioned, this was conduct which was protracted and repeated. It was targeting towards a specific individual and had misogynistic overtones. Further, the comment regarding beheading was completely inappropriate for the reasons mentioned earlier. We have considered the impact of this conduct on others. Such behaviour has the potential to, and to some extent has, negatively impact upon individuals, on the Sheringham Town Council, on the community, including those who may be vulnerable, on his political party, and on democracy. Mitigating factors. The subject member has made a suggestion that he would apologise to the member of the public, but this mitigation is minimal, as it is not considered a clear offer of apology as it was qualified. Recommendations. The committee considered what recommendations should be made to Sheringham Town Council in respect of sanctions. It considered, with reference to its findings and the aggravating and mitigating factors, that the following sanctions would be appropriate. A report of the committee's findings be made to Sheringham Town Council. A formal censure be issued proclaiming the disapproval of this conduct. An apology be made by the subject member, by him personally, to Councillor Withington and Miss Prince at the next full council meeting of Sheringham Town Council that he attends. In the event that the subject matter is appointed to external bodies by the Town Council, that such appointment is removed until after the completion of training identified below. The committee recommends that the subject member be required to undertake and complete appropriate training in standards training, code of conduct, training relating to bullying and harassment, social media training, equality and diversity training. These should be within 6 months of the date of the hearing, 30th of the 6th, 23. Such training will be considered appropriate where it is approved in writing by Sheringham Town Council and will be considered as completed where Sheringham Town Council is satisfied that it has been completed and provides such confirmation in writing to the subject matter member. It is recommended to Sheringham Town Council that does arrange such training within this period. It is further recommended to Sheringham Town Council, if not already done, to consider adopting Debate Not Hate campaign and toolkit provided by the Local Government Association. Thank you very much. And I close the meeting. Thank you very much. at 2:30. Thank you very much for your attendance and your help and everything else. Thank you.